Good evening. I'd like to welcome everyone to the 10th workshop of the Business Plan Competition Series for 2012-2013. I'm John Rollins, the director of the competition, and we are very fortunate this evening to have with us Peter Weissman, Esquire. Peter is a partner with the law firm of Blank Rome, just across Virginia Avenue in the Watergate office building. And I might add that Blank Rome is one of the sponsors of our business plan competition this year. In fact, they're one of the highest level sponsors, called the Platinum sponsor. Translated, that means that Blank Rome is sponsoring the $10,000 second place prize in the competition. Peter is an expert on intellectual property, knows also a lot about, as a subset of intellectual property, about patents. And the way you learn about patents in this country is to work at some point in your career as a patent examiner for the U.S. Patent and Trademark Office. Peter did that. He put in his time there and then joined Blank Rome, and now he's a partner with Blank Rome. So without further ado, I'd like to welcome Peter Weissman.
Thank you very much. Glad to see everyone come out tonight. I know the skies are looking a little threatening, so hopefully it won't be raining by the time we get out here. As John mentioned, I'm a partner at Blank Rome. We're a large law firm. We have an office here in the Watergate building, and we also have offices in New York, Philadelphia, Hong Kong, Beijing, and Los Angeles. So we do a wide range of legal services, not only intellectual property, but also corporate, government relations, government contract work, emerging business work, which involves the formation of companies as well as the identification of investors and growth of companies. So John has asked me to come here today and speak about both corporations, forming your own company, and intellectual property. So that's what I'm planning to cover today. At any time, feel free to interrupt me with questions. I have a presentation that I'm going to go through. Don't feel obligated to rush to jot things down. If you're interested in having a copy, you can email me. My email address is on the screen, weissman@blankrome.com. And you could also email John. I expect if you email Denitsa, she'd be able to find me if you lose my email address. I'm also one of the founders of a group we call GW Entrepreneurs Roundtable, or GWERT for short, GWERT. And I have that at the end of the presentation, but that's an alumnus organization for alumni who are interested in entrepreneurship here on campus. So, feel free to join our LinkedIn group. It gives you information about what's going on now, and also as you all become alumni, you'll hopefully remain engaged with GW. I put down here a couple of legal pitfalls that we see with startup companies, and I assume here that just about everyone is some form of a startup company. You're all just emerging with an idea. You don't have a lot of funding. And these are some of the things that we see that startup companies will sometimes have difficulties with. As they mature into larger companies, we'll realize that they'll come to us and we'll find certain things that they could have perhaps done a little bit better. It also gives you an overview of some of the legal issues that you should be thinking about as a young company, and to keep in your mind some of these ideas may not have occurred to you in the past. You're going to have a wide range of issues, whether they're employment issues, intellectual property issues, forming your company, maintaining your company, all sorts of wide range of things. So I just put down a few things here for you to look at. Budgeting is probably the most important thing for you, and it may not be something that you can budget for currently, but it's something that as you develop your business plan, you should put in a line item for budgeting for legal expenses. That can be a big detraction for some startup companies, because if you don't properly budget for your legal expenses or you don't anticipate legal expenses, those expenses can come back and kind of haunt you later if you haven't budgeted for them. Choosing the wrong legal entity, actually I put that one down there, but that's becoming less and less of a problem. I know startups are always so concerned, should I form an LLC, should I form an S-Corp, should I do a C-Corp? What does a nonprofit do for me, if anything? And to tell you the truth, unless you have an investor knocking on your door who's saying, I need to have an S-Corp, I need to have a C-Corp, or why aren't you formed as an LLC, it's not going to really make that much of a difference to you. At one point, certain investors were interested in certain types of companies. John, please correct me, let me know if you have different experience, but nowadays you can work with an LLC, and if you come on on an investor who just says, I feel much more comfortable if you're formed as an S-Corp, then you just convert your company into an S-Corp.
That's right.
It's something we do all the time, something that even well-established businesses are constantly changing their legal structure to form subsidiaries and the like. So as the laws change, they do different things. It's not something that's static for any business. It's something that you always have to keep an eye on and figure out if you're doing the right thing. I don't want to go into too much detail on every little point I have up there. Some of this information is more for your reference, and I don't want to. But if people have questions, certainly feel free to answer, to ask me. Product liability insurance. If you're intending to offer a product out to the market, you want to certainly budget for product liability. You want to investigate what are the terms. A law firm can also be an unusual resource for you, and sometimes people don't realize that. But we have people on staff who negotiate liability insurance, and they'll negotiate the terms of that insurance. Sometimes we represent the insurance company, sometimes we represent the company who's looking for the insurance. So you can call us, and I will say who we recommend for your business for product liability. Now, it may not always be a perfect fit, but sometimes you should realize that your law firm can operate as that type of a service to you. So we're not there just to do legal work, but we have a very good interest in making sure that your company succeeds. So if you need a product liability, we can recommend the broker to you. If you need to find real estate, we can recommend a business realtor to you. Someone who we trust, someone who we worked with in the past, and that we feel comfortable recommending, because if it doesn't work out for you, it ultimately reflects back on our firm. And a company just came to us a little while ago. They were real excited. They've been out there. They're still a startup, but after 2 or 3 years, lo and behold, the Goliath in the industry is interested in licensing their product. They didn't have a business plan together. We recommended someone who we've used for years to do a business plan, and it's really going very well. Happened to be that it's in the healthcare industry, which we have a specialty in that area, and we happen to have somebody who is very well suited to their business. Agreements, everybody knows that when you have several partners, it's a good idea to put forward some sort of an agreement. You can call it a founder's agreement, or if it's an LLC, it's the operating agreement, or whatever it is, something in writing that establishes your understanding as of the date of what your responsibilities are going to be, what your interests are going to be. Some people may have heard of a vesting schedule. I'm probably getting ahead of myself a little bit. But a vesting schedule is a situation where you have 3 or 4 people. Day one, everybody is gung-ho. We're going to do this night and day. This is the greatest thing. We're all excited about it. And then, next week you realize, I got a test coming up. I can't do the business this week. And before you know it, 6 months go by and 1 or 2 people are starting to straggle. They've lost a little bit of interest. So a vesting schedule is something that, exactly like it says, it vests the interests of the partners over a period of time. So if you say, okay, we got 4 people, we're going to have 25% each, well, it doesn't vest. You don't get the full 25% up front. after a period of 2, 3, 4 years, well, 4 is probably a little long, but after 2 years, it would slowly vest. So every 6 months, you get another percentage of the company. So that way, if somebody loses interest, they don't have the full 25%. They have something a little bit less. I put non-compete agreements in there. People often like to use the specialties that they've learned at a prior company, and they bring that to form their own company. So you have to be careful that when you do that, just make sure if you have an employment agreement with the company, it may have some terms in there about what you're allowed to do and what you're not allowed to do. May have a period of time where you're not, or a geographical area where you're not allowed to basically go into competition with your former employee. Aside from that, there may be trade secret issues. You don't want to, steal their customers, so to speak. You want to be careful with what you do and how you do it. We regularly advise on that type of thing as well. Turning to forming a company, the main reason, and I think most people probably know this, but I'll say it even if it's obvious, the main reason you want to form a company is to insulate yourself from liability. Well, I'm a student, I really don't have that much, I have an old clunker, I might have a little money in the bank account. That doesn't matter. You form an LLC is cheap, it's relatively inexpensive to do. Most states you could do it online, and it insulates you from liability. So that means if you have a product, you start selling it, and unfortunately somebody gets injured or somebody hurts themselves, or the product doesn't work the way it's supposed to, and you end up failing on a contract, breaching an agreement, and somebody comes after you. What it means to insulate you from liability is that when somebody comes after you, they can only go after what the company is valued at, only what the company assets are. They can't come after you, they can't get your old clunker, they can't get your laptop, they can't get your data, they can't get your software. Well, that may be part of the business. But anything in your personal possession, any of your personal property is insulated from liability. Now, at the same time, the exchange for that is that you have to maintain that corporate formalities. Some types of companies, you have to have annual agreements, you have to do bylaws, you have to have regular meetings. If you fail to do that, even if you have an LLC and you don't have a bank account in the name of the LLC, and you just pay for things out of your own pocket, and you're mixing, they call it commingling, where you're mixing your personal interests with your business interests. If you do that, then there could be a breakdown in the insulation of the liability. So if somebody comes after you and they said, I hurt myself with your product, say, I got this LLC formed, but you haven't been treating it as a business, you've been treating it almost as yourself, then the court will cut through that, and they might be able to get your clunker. Did you have a question?
Yes, I was just curious. For example, say that you have a patent that you own individually, but it's not a part of the LLC. Could and then you've licensed it to the LLC to use, and you end up having somebody come after you? Are they able to come after that patent, for example, or is it just the ability to license that patent?
So I'll just repeat the question because we're doing this on video, so in case they couldn't hear. So the question was basically, if you have a patent in your own name, can they come after the patent or is it covered by the LLC? So that's kind of a tricky question. So if you have a patent and you also have your own company, and essentially the company is using the technology in the patent, there may be a verbal or an implied license. So to the extent there's any sort of ownership, and ownership I mean some sort of right of the company to use that technology, then it's possible they could go after that portion of it. It's even possible that if depends on exactly what the situation is, that they would be able to go after the patent. But if you own it in your own name, are you giving a license? Are you getting paid on the royalties on a regular basis? How separate is it from the company? Is it just that you have it and you're assuming that the company is using it, and you use it, and you're allowing the company to use it? There may be a breakdown in the liability. So that kind of a good segue into the next point there, is establishing a company is a great way to establish ownership of your assets. And particularly important, I'm a patent attorney, so that's important to me, but intangible assets, you can put your patent in the name of the company, and depending on the situation, you probably should. Any trademarks you have are going to be owned by the company. And that's very important because, like I said, if you have several people, several partners, and you're all together, and then there's a parting of the ways and somebody leaves, well, now the patent is owned by the company. And it's without a doubt that the trademark is owned by the company. So you don't have a situation where somebody splits off and says, oh, that's my trademark, I'm going to start using it. And then the other people want to do the same thing. So the trademark establishes ownership. The company allows you to establish ownership in that. So whatever everyone's share is in the company is their share in those intangible assets. But it's also for, of course, owning your tangible properties. Whatever property you may own, whatever equipment you may own, stuff like that. You want to do all agreements, employment agreements and the like, any consulting agreements, any manufacturing agreements, distribution agreements, and have it all in the name of the company so it's clear who owns it. The last point on this slide is somewhat interesting. It simplifies the investment process, and what that means is that if you do come along across an investor and that's your objective is to develop investment in this business, then you have your company set up, they can invest in the company, and you get a percentage. It's clear that they're assured that there's ownership. Yes, Ed?
Hey, how is an MOU, memo of understanding, how does that play over here? Or does it?
So the question was, how does a memorandum of understanding relate to this? And they call that an MOU sometimes. So usually people will use MOUs in order to establish an initial relationship before they actually enter into the formal agreement. So an investor may come upon you and say, I like what you're doing, I'm really interested in investing, but I need to do my due diligence. I need to check all your corporate records or your company records to make sure everything's copacetic. I need to speak with the other partners. I need to check your agreements. I need to make sure your exportation license is in order. So they'll do an MOU, and they'll say, these are the terms that I'm interested in. I want a certain percentage for a certain investment, et cetera, whatever they want to put into that. And sometimes they'll often say, but in exchange for that, I want you to agree not to speak to any other investor for a period of time. Maybe 6 months, maybe 2 months, just whatever you're able to agree to. And that allows you to put all your stuff together. And the due diligence is a process where the investor will have their attorneys oftentimes, or business analysts. It could be that they're looking to see if you're running the profits right and calculating all the margins and everything properly, and you're following your accounting procedures. Well, there's a period of time where they can then investigate the company, see if it stands up to their scrutiny, and either follow through with the deal or not. Did that answer your question?
Yeah, but so are you protected if you have an MOU and before an LLC or whatever? Are you legally protected, or should you establish the LLC first before any MOU, and if vice versa, if the MOU is before the LLC, are you going to be protected? So
the question was whether the MOU comes before or after the LLC, if it's going to give you some protection. So the best thing to do is, before you really start the business, the first thing you should really be doing to start the business is to start the business, to start the company, register the LLC or your CCorp or whatever else you're doing. Now, if you happen to have an MOU, you just can't wait. It's going to take a couple of weeks to get the right papers together or something like that, and you just have to do something. Once the company is formed, you should transfer that into the name of the company, and you could put in the MOU that it's intending to be transferred over and it's a transferable agreement. MOUs are not always 100% binding. They're kind of an intent to agree, and people can back out of them, but did I answer it that time?
Yeah.
Okay. Yes?
Quick questions about LLCs. I've recently formed one and wanted to keep the brand of the company separate company. Haven't mentioned that possibly want some equity stake and bring in other members. Is there any advantage or disadvantage in keeping the branding of the company a separate legal entity, separate from the first company?
So the question was, he owns branding in a first company and he wants to form a second company, and is there an advantage to keeping ownership in one versus the other? So trademarks are a little, you have to be careful with them. So if one company is going to own the trademark, you should do a written agreement to license it to the other company. And the thing with trademark licenses is that you have to put in there some sort of oversight of the company, the owner of the trademark, to make sure that the quality of the goods and services are in line with the expectations of the owner. So, you know, McDonald's just doesn't let you open a franchise. They come there, they inspect the premises, they make sure that you're ordering the right product, you know, the product from them. So it's the same thing, you have to watch. Now, that doesn't mean that you're operating a Rolls Royce. You could be a Chevy, but, you know, whatever your standard is for that trademark, you want to make sure that the licensing party is in line with that, or, you know, whatever you license them to do. Did that answer your question?
Yeah, I just kind of wanted to have the ownership of the sole proprietor LLC that has the trademark and everything else, and then the part that gets the equity stake with other investors, just keep that separate.
Yeah, you know, when so the question was whether he should keep some of that separate from the two companies. You know, there's always a tendency of the person who's founding a company to want to own in his or her own name as an individual, whether it's a patent or a trademark, to keep as much property in their own personal possession. And when an investor comes in, that's one of the things they look for. They want to make sure that the company owns those rights, because they don't want to have to deal with a situation where, you know, they're investing in a company that may or may not have any rights to a trademark. So but at the same time, we have clients who he kept the patent in his name for 30 years, and when we had to sue somebody on it, we had issues over it. So it just depends. I mean, sometimes there are tax reasons to keep it as an individual. Sometimes you can form a company which licenses it to the other company. But whatever you do, I think you should put in writing what the relationship is between the two companies, so that there's no misunderstanding. I'm not sure I exactly answered your question yet, but we can speak if you'd like. Okay.
When you're working with an LLC, the vesting schedule, what do you, when you say you're divvying up it's not shares, because you don't have shares in a LLC, or do you? How does that work?
Well, the LLC, you have an operating agreement. So the operating agreement will say, I own X percent. Yeah. So you can, you know, have a situation where you could do an agreement that says that it could even be part of the operating agreement, which says that over a period of time, it'll slowly vest.
Okay.
As I kind of touched upon a little bit, you can't commingle funds, and a company should not just be a shell for you as your individual person. And then the last thing I put in, I mean, you know, clearly, as you start seeing profits or in your company, or as you see that your business plan is going to work or has a good likelihood of working, it's a good idea to check in with a lawyer or your accountant or whoever else it happens to be, your insurance broker, just to make sure, am I doing things the right way? You know, am I covered? Am I, from a legal standpoint, is ownership tied up? Do I have my corporate records in order? You know, what do I do? Did I kind of screw something up earlier that I can fix now? And sometimes you can't fix things. Employment agreements as well. you can kind of update those, and especially when some of your employees are giving a promotion or a raise or something, that's a good time to look at those agreements again and say, hey, do I have the right employment agreement in place? Does it cover me? Is it assign all ownership of patents to me? Consulting agreements as well, that sometimes we see where people just say, oh, I'll just have someone develop the software, and they don't put in there who's going to own the intellectual property. That's something you want to be careful for. LLC, I think probably, people tend to be most familiar with an LLC out of all the different types of entities. And it's probably the least scariest one. As I said, it's something you can do online. A lot of states have websites where you can just, go through the process. One thing that I do like to caution people about is when you do it online, you'll often say, okay, what is the name of your company, and do you want to register this as a trademark? That is not a federal registration. That's a state registration. They're much different, and when we get to trademarks, I'll be talking about federal trademarks, which is the real trademark. It's the U.S. Patent and Trademark Office. When you register online, don't mistake that. People often say, "Oh, I registered that years ago," and we'll look and we don't see anything, and they'll have the misconception that because they've registered that in their state that they now own, that's a registered trademark, and it's not the same thing. So an LLC, there are no tax advantage or disadvantage. It's just a kind of pass-through. You have an operating agreement. You could probably find a fairly standard form. It's probably not the worst thing to use LegalZoom for an operating agreement or an NDA. But again, it's something that people will come to us after their business starts to mature, and we'll tailor it more, we'll customize it, we'll make sure it fits your company. And an LLC is relatively simple to form and inexpensive to form. CCorp, so the companies I'll discuss are just the LLC, the CCorp, the S-Corp, and just nonprofits. So CCorp, as you see, they're a little more complicated to form, especially if you want to do them properly. I mean, oftentimes you can register a company. You can even do an S-Corp or a C-Corp. Sometimes you could do those online, and it may not seem all that complicated. But again, I would just say that when as you go forward, you just want to make sure that you're in the right type of company and that it's set up properly. S-Corp, one of the differences between the S and the C-Corp is that you have to distribute based upon the number of shares, and both an S and C Corp are considered corporations. So it's more of a more formalities. You have to file regular reports. You're going to be taxed based upon your employment, salary. I just put a couple of bullet points up there. Nonprofit organization, these are actually probably one of the more complicated entities to form, which is surprising because it's a nonprofit, so you'd think it'd be really cheap to do it. But these are fairly complicated, and they can take a long time depending on what you want and how you want it done. There are charitable type of nonprofits, and there are tax deductible. So just because you're charitable doesn't mean you're tax deductible, and just because you're non-charitable doesn't mean that you can't have a tax deductible. So I just put up nonprofit. Not too many people are interested in that. Most of the companies that are in the business plan are interested in making a profit.
Did you just say on the last slide that the S-Corp was paying out dividends? So I thought they pay only distributions.
Yeah, you could. You have to pay out distributions based on the number of shares.
Right, so what does it mean exactly, no employee tax on dividends?
No, just the employee tax versus the dividend tax versus a So it's just two different rates of taxation.
Right,
Although-
but I'm just not understanding what you mean by no employee tax on dividends.
FICA? No employee tax?
Yeah, yeah.
He's referring to FICA,
Oh, okay.
I think,
Okay.
but Social Security tax.
The other thing with nonprofits is that you can pay yourself a salary, so just because you're working for a nonprofit doesn't mean that you're not earning money. People always think about that, the administrative overhead when they donate to a charity is, they're concerned about how much money is going to the people who work there. So just because you're a non-charity doesn't mean you can't earn a salary doing it. The other thing about a non-charity is that it has to be for a charitable purpose, which means that any profits that you have in the company are put back into that charitable purpose. It has to be an authorized charitable purpose. Did anyone have any other questions before we move on to patents and trademarks? So a patent is anything that any sort of new improvement that you have made, you can think about getting a patent protection for. The Supreme Court has said that a patent can be applied for anything under the sun, so that's a pretty wide scope. In the United States, you can patent software, you could patent methods, you could patent devices, you could patent manufacturing techniques, anything you think about. Anything that is giving your business some sort of a competitive edge, you should think about whether you should be applying for a patent for this. Patents are relatively expensive. To go full fare for a patent can be $10,000 to $15,000. We'll talk about provisional applications, which are cheaper to do. And people will often say, I just don't have that kind of money. Is it really worth it to me? And the thing I like to put in their mind is, especially for a business plan competition, what are you saying about your business? What are you saying about your company? Is your company going to just be selling another brand of pizza? If an investor comes to you and say, why should I invest in your company? You'll say, well, we have a better product. We have a different product, right? And he says, well, where's your patent? And he says, oh, we didn't think we needed a patent. Well, how are you going to protect that distinction over what your competitors are doing? How can you tell an investor that I'm doing something different, something better, but I didn't think it was worthwhile to get a patent? So, I don't want to sell you a patent. Not every company is going to need a patent. Not everyone's going to be able to get a patent. But that's, to me, there are several reasons to get a patent, not only from the legal protection, because it can be expensive to enforce, but you can use it for marketing purposes, and you certainly can use it for investment purposes. And if an investor comes to you and you just say, you didn't do it, that might undermine the person's perception of you, because either you weren't thinking along the lines of getting legal protection, or they don't want to invest in a company where somebody else can come in the next day and compete with you, perhaps at a lower overhead, because they didn't have to develop a patent.
What about a completely different use of something that is already patented?
So the question was whether you can patent something that is used differently from a prior product. So 99% of the patents out there are what we call improvement patents. There are very few situations where somebody will search for prior art and there's just nothing out there. So you're improving on what's been done before. So using a device for a different purpose can qualify for patent. It's more difficult, and I've had trouble with certain examiners. The examiners don't always see that, and you could cite some case law and stuff, but depending on what the application is, you should be able to do that, but it can be a little more difficult.
Same amount of time, I understand, like 4 or 5 years to get a patent.
Yeah, the question was how long it takes to get a patent, and I'll cover that, but it depends on the technology. It can be anywhere from 1 to 6 years just to get an examination. So what does a patent do for you? It doesn't mean that you can make and sell a product. You still have to get whatever government clearances that you need, but it gives you the right to exclude others from practicing your invention. So that means you can prevent your competitor from making it, from selling it. exporting it or importing it. Standard patentability is whether it's obvious to one of ordinary skill in the art. And that's kind of supposed to be an objective test, but it's somewhat subjective. An examiner just can't say, this is obvious because I think it is. They have to have some reason to say that, so they often look to what we call the prior art, meaning the prior patents and stuff. You can search for prior patents on the Patent Office website, which I have at the end of the slide. But the practical test that I like to suggest to people is what I said before. Is this really giving you some sort of commercial benefit? Is it of any value to your company? Because if it is, if you're doing something different, then there has to be something behind it which you could potentially qualify for a patent for. And we see this all the time, even with our big companies. They have engineers working on things, and I'll say, well, what are your engineers working on? And they'll tell me, and I'll say, well, why aren't we filing for an application for that? Oh, well, we just didn't think about it. And, you know, so people, if you have engineers, researchers working on a problem, if they have a problem, they say invention is, or necessity is the mother of all invention. So that means if you have a problem, then your solution to that problem is where the invention lies. Some of the advantages I put up here as well, you know, you also want to think about your competitors. Are your competitors getting patents? And if so, your patent can operate as prior art to them. So that's somewhat of a defensive technique. You know, if you have your patent out there, that means that someone else can't come along and try to get a patent on a similar idea, or if they might be able to get a patent on improvement, that would set up a potential cross-licensing situation. It increases the value of your company. You can always license your patents, so you could use that as a revenue stream. Again, if anyone has any questions about any of these points, I'm happy to discuss them. The cost is certainly not only a substantial cost financially, but there's a big cost to the company as far as the time it takes. So if you only have a few people in your company, it could take 30, 40 hours on your side of things to put the material together needed by the patent attorney. That can be a substantial amount of your time, and it may not be time that you have able to set aside. Again, it doesn't give you the right to make yours and sell. It is possible that somebody else would have a patent out there that you should consider as to whether you're infringing or you would need a license to it. Provisional application is, there's two types of patent applications. There's a provisional and a non-provisional. So a non-provisional is a full application, which means that a provisional is something less than that. And a provisional is something that people use because they don't have the money. They don't have that $10,000 to $15,000 to do a full application, so they do a provisional. Or they're going to be disclosing the invention soon. They want to get it on file quickly, so they'll do a provisional. So there's several reasons that you would do a provisional application. Essentially, a provisional lasts for 1 year. It doesn't have a lot of formal requirements, so we don't have to write claims. We don't have to put together all the sections that are required for a normal patent application. And it allows you to do it quickly and less expensively. So a lot of companies will do this, and it's not my preference to file a provisional. It's always best to do a full application. But if, you know, given your financial and time constraints and potential other constraints, it may be that a provisional is well suited for you. And once you file it, you get a patent pending status. I wouldn't necessarily recommend LegalZoom for a provisional application. It can help you technically file the application, but the real, I can't say exactly, I haven't worked with LegalZoom, but to get the meat into the application is the important part, and you really need somebody to look at that in order to help you out. When I was working at the Patent Office, I worked there for 3 years. As soon as you open a file, you knew whether somebody had an attorney or not. It didn't happen so often that people didn't have attorneys, but it was immediately clear. And the same thing happens here. I have a lot of people who come to me and say, I'm going to write the whole thing. All I want you to do is do a quick final review, and it'll save me a ton of money. It really hasn't worked that way very often. I've had one or two people who are able to do that, and I've been practicing longer than I'm going to tell you. But it really doesn't happen that often. It's just a particular way of saying things, and it has to be a very methodical and detailed description. And it's not the type of writing that people are typically accustomed to doing. So anyway, I did offer to John and to the people in the business plan competition and anyone who's here, I am willing to look through any provisional application that anyone wants to file. I'm happy to give you my review of it, and I'll give you my comments. And I may even do 2 or 3 iterations with you, just depending on my time constraints. But if you want to put together an application, just put down a detailed written description. I don't know, John, did you hand out the provisional, the two-page sheet? Did they all have that?
Not tonight.
Okay, I brought some copies with me. I have a two-sided sheet which says, what you need to put into your provisional application. If you want to email me for it, I have some copies today, but if you want to email a copy as well, I'll send you that. So you can use that as a rough outline to help you put together the application, and then you can send it to me. I'll read it through. I'll give you my thoughts on it, and you can make some revisions.
Peter has put more good information into a 2-page handout than you can believe. So I recommend that you get one of his handouts if you're all interested in pursuing a patent or provisional patent.
It's pretty dense with information. Did anyone have questions about a provisional in general?
You had potential bar date. What is the bar date? And
bar date we'll get to, actually. Bar date is one of the most important takeaways.
In the very last, your non-provisional will not benefit the provisional, but does not disclose each element. So you have to get everything into the provisional, or only the things that are...
So the question was whether you had to have everything in your provisional. That one of the dangers in filing a provisional application is that people just throw something together quick. It's broad, it's not as detailed as it needs to be, and they think, oh great, now I have a year, I can just sit around and try to market my invention, which is the reason you would file a provisional, is you want to see if this is marketable and economically worth it to pursue the full application. So you have a year to go through testing. But if your provisional isn't as detailed as it needs to be, and let's say your invention is A, B, and C, and a year later you go to convert it, and you realize, oh, I left off C, or I didn't describe C sufficiently, then the filing date of the provisional might be lost. So that's why it's kind of dangerous to rely on. If you do file a provisional and you find that it's going to be worthwhile to pursue this invention or pursue this business, I would recommend that you not wait the 1 year, and to the extent you could do it sooner, you should.
Can you extend a provisional for more than 1 year, and after 1 year, can you extend it?
So the question was whether you can extend the provisional. There is some sort of temporary thing where you can request 2 years, but it's really it's not done very often, and it's a temporary thing with the patent office. I don't know if they're going to continue that practice or not. I haven't seen much discussion of it lately. But the short answer is no. After 1 year, the provisional expires. You can refile a new provisional, but you'll lose the date of the original provisional. And that date could be very important if we're going to talk about disclosures in a minute here, and you'll see why you might need that filing date. Did I answer all your questions? So statutory bar, if there's going to be one thing that you should remember from today, it's statutory bar. Essentially, in a nutshell, you want to file your patent application before you disclose your invention. And it could be you can make a disclosure through any number of things. It could be a website, it can be a speaking engagement, it can be just going to a lot of people and talking about it. It could be potentially even a classroom discussion, and it can be the business plan competition. So before you make a disclosure, it's best to file a patent application. Now, if you've already disclosed your invention or part of your invention, The U.S. gives you a 1-year grace period, and so once you have that disclosure, you should write it down. You should make sure, in 11 months, not 12 months, 11 months you need to do something about it. And the reason I say 11 months is because even if you come to a patent attorney, it takes us at least a week to turn around the disclosure to you, and we prefer to have closer to a month when we can. So, well, you may be thinking, well, I'll just disclose it, and then I'll wait the 11 months. So why do I need to file it now? Well, the answer is that most foreign countries do not give you that 1-year grace period. So if you disclose the invention today, and you might have a big market in Europe, then you better file a patent application in the U.S. Before you make a disclosure, because if you wait the next day, you could be too late. Now, they're not always as concerned with things that are done under confidentiality. As a lawyer, we're always more comfortable when you file your invention before you do anything. But as a practical matter, things like a confidential disclosure to somebody, or disclosure under expectation of confidentiality, telling your mom or your sister about it isn't going to be a problem. But if you have some sort of publication of the invention on a website or something, or you talk about it at some convention and it appears in writing, then you want to, if that publishes, the next day you can't file for a patent and subsequently go into Europe and a lot of other countries, although you still have the 1 year for the United States.
Peter, you mentioned that the business plan competition could be a disclosure. I assume you're talking about if they make it to the finals and stand up in front of an audience and have it videotaped and put on a website, because in the first round and in the semifinal round, it's just read by 3 judges who don't publish it or publicize it. Right.
Yeah, that's actually the same thing with if you write a research paper and you submit it for publication. The submitting it for publication is usually not a problem. It's when it's actually going to be published, because the reviewers are under an expectation of confidentiality.
That's right.
So the same thing with the business plan competition. The first round may not be a problem. The second round may not be a problem. The last round is definitely a problem. Well, not a problem, but a disclosure. And, arguably when we have the 32 judges, that round, that's arguably a disclosure. So, would you mind closing that door? Thank you.
Thank you.
I put up over here a few things that are particular to students and mostly to grad students, researchers. I mean, not a lot of undergraduates are publishing papers and stuff like that. But I put up a few things here. Especially if you're going to publish something in Gelman, it goes online like that. That's a publication, so just be wary of that. Yes.
The grant proposal, I thought those are confidential. They said that they don't disclose to anybody.
The question was whether a grant proposal is a publication or not, a disclosure. The answer is sometimes they are through the FOIA Act, Freedom of Information Act. You can access them. And it doesn't matter if nobody ever accesses them. It doesn't matter if it's been in Gelman in a catalog. If it's cataloged in Gelman and nobody's ever accessed it, that can be still be a publication of it. So it depends. Not all grant applications are that way, but some of them are. So you just have to know, when you're going through the process, is this something that's good? It's the application, whatever you put in the application. And again, if you have a disclosure and it's a very general, what we call non-enabling disclosure, it may not be a problem for you as much. The lawyer side of me still says you want to file before that. But, say, I put in a grant application 3 years ago, I'm out of luck. Well, if the grant application was really vague and unclear, and you've really made a lot of revisions since then, you could certainly apply for those improvements yourself. So.
Well, in particular, it's an STTR or an SBIR. The way it was explained to us in the question and answer session on that is that all the reviewers are required to keep it confidential, and that all the papers get turned back in. And yes, a FOIA could be applied for, but never actually happens. But there's also something in there about you can mark certain pieces of the grant application as being confidential information. Now, I don't know if they then redact those sections if somebody does get a FOIA request or not, but maybe.
So the question was whether some of these grant applications, if information is redacted from the application or the application process represents that it's confidential. I think you're probably okay. I mean, it depends on the situation, and it depends what is actually available through a FOIA request. Do you want to trust the staff who are representing it to you? I can't tell you. You know, we've all had experiences where you call the same company or the same government agency and you get 2 or 3 different opinions. So, again, the lawyer side of me says err on the side of caution, but the practical, realistic side may say that if they're saying that it's not going to be confidential, a disclosure of the information, then you may be okay. And if they're saying that they're going to redact information, you may be okay. So just a couple other things on here for your edification that are directed more towards students. The big pitfalls, like I was saying before, is that people just don't understand, yes, I'm doing something that qualifies for patent protection. You don't have, Einstein isn't alive anymore, and he's not, you know, they're still filing over 150,000 applications every year. So whatever you're working on is something that can qualify for patent protection. We even have trouble getting that message through to our larger companies. On March 16th, and that's one of the reasons we kind of pushed this presentation forward a little bit, is because March 16th, the Patent Office transitions. Currently, we're under what's called a first to invent system, and on March 16th, we're moving to a first to file system. What does that mean? That after March 16th, if somebody has a publication which happens to be a week or 2 before you filed your application, even though you've been working on it for a year, you can no longer predate that. And the U.S. over the last 5 or 10 years, they've been moving more to be in line with what the rest of the world does. The rest of the world has always been first to file. They've always published their patent applications. They've always, they have the 0 grace period. We still have our 1-year grace period. But the reason we're moving, I feel, is because we're trying to transition to be in line with the rest of the world. So basically, if you have an invention currently, it's to your benefit to file before March 15th. So on the 16th, it converts over.
I have a scope of the discussion, but we read the Mandiant report last week about teams in China stealing intellectual property. That's going to hurt us heavily because they're just going to steal all this intellectual IP before people file, as they're in the R&D server, they're constantly hacked. That's quite amazing. And the 16th has been changing over.
Yeah, so the question was, there was the Manny report about the situation with China. I have it in my email. I've been out of town, so I haven't read it through thoroughly. But yeah, my understanding is that there could be some sort of issue there brewing. I mean, the thing about patents, technically, is that you can't go to another country. And I've had people who've done this before. They'll come to me. They'll say, "I got this great thing," and I'll say, "Where'd you find this?" "Oh, we bought it in Europe." Well, you can't patent it. You're not the inventor. You have to be the person who actually invented it. You conceived of it, and we have part of the process is the Patent Office has you sign a declaration that says, "I am to my knowledge, I'm the sole inventor or the joint inventor, and this is my invention, basically."
Even under first to file.
Yeah. So, but it is a first to file system. There is a twist about if I disclose it and then file a patent application, what happens there. I think that's a little too much for today. I would still encourage you to file before you disclose to preserve your rights in other countries. Another thing is inventors should all be with your company. I put up some patent pitfalls. The issue here is that if you have a consultant doing some work for you, you hire them to design, let's say, one part of the system. They may come up with some thoughts during that, and as a result, they may become an inventor. And like I said, you have to follow the application in the name of the inventor. So if you are the inventor, if you conceived of that, then they have to list you as an inventor, and you then are a joint owner in the patent application. So if you have a consultant who's doing work for you, or someone who you're going to use for design and development and then ultimately manufacturing, you don't want that and have to have them end up being an inventor and a joint owner. So the way you handle that is, like I said before, you want to have an agreement in place which says that any inventions that come out of it will be owned by you or your company. I think I'm going to skip ahead to the to trademarks because we're getting a little late. So, trademarks. Not everyone here is going to be able to get a patent, or may not have a technology or something that is something they feel they can patent. But almost everyone can use a trademark, and the reason for that is because from day one, you're going to start building goodwill in your company. Whether you're selling a Chevy or a Rolls Royce, you want to establish the quality of your product and your service as in your company. So a trademark does that. It's what we call a source identifier. When you look at a box of pizza here, it says Papa John's on it, right? You immediately know where it's coming from, what it's going to taste like. Doesn't matter, I don't know if they're sold outside the D.C. area, but you could be in Wisconsin and you see a Papa John's, or you see a McDonald's, or you walk into a store and you see an Oreo cookie sitting on the shelf. It identifies for you who's making the product. You don't have to necessarily know it's a Nabisco product, but you know what it's going to taste like, you know what to expect from it, you know what the level of quality is, and what it's going to taste like. It's not going to taste like a Hydrox. It's going to taste like an Oreo cookie. And you're going to be upset if it doesn't. And that's one reason we discussed before, when you're licensing, you got to make sure that they're maintaining that level of quality. So it can be a word, a name, a symbol, a logo, a variety of things. If you have a logo, you shouldn't only apply for the logo if you have a nifty idea. If it's Papa John's or Pepsi or Coke and it has a fancy logo or symbol with it, don't only apply for the logo, but also do the word by itself. And like I said, there's a difference between a state trademark and a federal trademark. Federal trademark operates nationwide and puts people on notice across the country so that someone in California wouldn't be able to register the same trademark as you. The other thing with trademarks is you could file based upon an intent to use it. So same thing with a patent. You don't have to wait. You don't have to reduce it to practice. You don't have to have a prototype. Used to be in the very early days of the patent office, you had to submit a working model, and they put those all in the Smithsonian. But you don't have to do that anymore. You don't have to have a working prototype, especially for software. A lot of that is somewhat intuitive. Once you say what it is and what it's doing, you realize how it's going to be implemented. You don't have to put your source code in. So I'm backtracking a little bit, but with a trademark, it's somewhat in a similar vein. You don't have to actually start using the trademark. And the best thing for you is to go to the trademark office website, also search the internet, see what other trademarks are out there. If it's confusingly similar to yours, then you may have a problem. But if you find something that's distinctive and isn't being used by someone else and doesn't merely describe the product, so you can't trademark the word cup if you're selling styrofoam cups. You can trademark it if you're selling toilets and you want to call it a cup, because nobody is, it's not descriptive, it's not describing the product. So once you come up with your name, you can file based upon your intent to use it. But you won't actually get the registration until you actually start using it, because they don't want people
squatting on trademarks, unlike domain names. You can't just go out and register 100 different trademarks and say, oh, I'm going to wait until somebody starts using this because it's the latest, greatest thing. You have to have it, and it has to be used. You have to be using it in commerce. It has to be a bona fide use. Even small marketing things are probably okay, but it has to be a bona fide use in commerce, meaning it's in trade, it's on a website, or you're selling a product, you're giving away a product, and it has to be on or associated with the product. It can be directly on the product, like a Pepsi bottle, or it can be on the packaging. If you're putting it in a package, in a box, on a hang tag or something like that. So the mark has to be associated with the goods or the services. I would encourage you to search to see if you can get a trademark, if there's anyone else using it, and if not, file based on your intent to use. The strongest marks are those that are arbitrary, something that just doesn't describe the product at all. Exxon for gasoline. I mean, who knows, what does Exxon mean? Did you have a question?
Can you get a trademark on web design?
The web design, like the GUI and stuff, yeah.
Right.
It may even be that you can get a design patent for that.
Design patent.
Yeah, and there's also something called trade dress, which is, it's not a formal trademark registration, but it could be for something like the place of business, a restaurant or something, or it could be the style of shoe, something that trade dress isn't necessarily trademarkable, but would still give you some form of protection. For software, it's something that comes up on the splash screen the launch screen when you first bring it up. It may be that you can try to put it in other places. Websites, you can get trademarks for those if you're using them in the right manner. I just put in some cute things there, I guess. Think globally. I like to tell people, well, Chevy Nova was selling the Nova. I don't know, it's ancient history from now, I guess, but they came out with a car that meant Nova, and in Spanish, Nova means no go. So, they weren't thinking globally, but it's not easy to do that, of course. And again, it distinguishes your products from those of your competitors. They see yours sitting on the shelf. They know it's not your competitors, or they hear about your services. They know it's not your competitors. I like to tell people about this early, but it's hard to remember this type of thing. If you do business in another country, if you have a manufacturer in another country, a distributor in another country, register your trademark in that country, because if you don't, your distributor may be. And if you have a falling out with your distributor, you don't want them to be able to continue to sell the goods or product in that country using your trademark. And I have had several real instances where we've had that problem, and we've luckily resolved them, but people just don't realize that when they go into another country that they should be registering their trademarks there.
Is it the same for a patent?
Yeah, patents are territorial, just like trademarks. So if I have a patent in the United States, like I said, you can exclude others from making, using, selling, importing, or exporting. But if somebody's making it in China and selling it in Europe, your U.S. patent doesn't help you. You need either a patent in Europe or a patent in China, or both.
China doesn't follow the WTO.
So I'll repeat the last question first. Sorry, just for the video. So the question was, are patents territorial and trademarks territorial, and I answered that. And then this question was whether China followed the WTO, the World Trademark Organization, trade organization. So as far as trademarks, I mean, you still have to register in China. I haven't had a lot of instances with China, but I mean, you can apply for a trademark there.
They're a member of WTO.
I believe so, yeah.
They are. I don't know if that means they follow WTO, but they are a member.
Well, you know, applying and getting the trademark or the patent, people, our clients do file in China because it's such a huge market, you can't ignore it.
Mm-hmm.
But they don't always count on that protecting them. My understanding of doing business with China is it's important to have a very reputable and large manufacturer. You don't want a small fly-by-night company there, because those are the ones who might run afoul of your goods or might use it for other things. But if you go to a reputable company, maybe a little more money, but my understanding is that you can deal with it. Yes?
For something like a website, would you put an SM on the name of the website? Maybe the logo for the site if you're not physically selling a product or a virtual good?
So the question was the difference between a SM and a TM for a website. So TM means trademark and SM means service mark. So the difference is if you're selling a bottle of soda, that's a product, that's a good, and that's a TM for goods. If you're a car mechanic and you're selling your services of repairing cars, that's a service, and you would use an SM. But once it's registered, whether it's an SM or a TM, it's a R in a circle. It doesn't really matter what you use, but that's the difference. And when you file your trademark application, you'll have to specify what are the goods or what are the services. And that's the most important part of the application. Well, not the most important part, but that's an important part of the application. The only information you need for a trademark is what is the mark, when did I first start using it in commerce, so you want to keep track of that. When did I first start using it anywhere in the world? It's usually the same date. And then what company is going to own it, and what are the goods and services. And if the goods or services, it's very important to be as thorough and complete as possible, and try to look ahead a little bit. Sometimes people may not realize that certain branding may be of value with merchandising, T-shirts, mugs, or whatever it is. So if that's something you envision, you would want to include that in your trademark application. Make sure that that's clear, because somebody may be registering for T-shirts for a different or similar type of goods that you just want to be careful that you can get it first. Yes.
Well, I might be misunderstanding. As far as I understand, there's a PCT, which is a global patent registration. Is there any such thing for trademark, like global trademark?
So the question was, there's a PCT application for trademarks, for patents, and is there something similar for trademarks? A PCT application is an application that you could file in the United States or other countries, and it preserves your rights to go into other countries. So the timeline is that once you file your U.S. application, you have 1 year to file in other countries. It's an agreement that the countries have with each other. You can either file directly in the countries, or you can file a PCT. If you file a PCT, it gives you an additional 18 months. But you still have to go directly into those countries. So a PCT does not become a patent anywhere. It's just an application, and it's a way of generating fees and delaying the ultimate cost of filing in other countries, because it's expensive. To file in Europe costs $10,000. That's after you have your U.S. application written. So in addition to the cost of filing, to writing the application and filing in the U.S., you're going to have $10,000 in Europe in another year. So if you want to defer that cost, you file a PCT. That costs $5,000 to $6,000. And if you're not sure what countries you're ultimately going to be practicing in, you may want to file a PCT. Especially, it's probably a good idea for young companies who aren't sure where they're going to end up. But anyway, as far as the trademarks go, there are some similar types of things, but generally it's just cheaper. See, the PCT is just an added cost. If you know what countries you want to go into, just file directly. The reason you file a PCT is you want to defer the cost of the countries or you're just not sure what countries you want to enter into. So, but for trademarks, most people will file direct, but there is an international proceeding. Yes.
Say you're starting a company that's more kind of global scale, so how would you, is there any easy way to tackle this, or do you have to file?
So the question was, if you have a business who's selling products globally, there's no easy way. We represent some big companies. I'm not going to say who they are, but if you're intending to open a business called Chairs Are Us, we're coming after you. So the way that they do that is by doing a really detailed search worldwide. If a company is going to roll out a big expensive product, we've done searches ridiculous. You can't do that. You can do your best to look online. You could go to Google Europe or whatever and look in other countries and stuff, but it's going to be difficult to do, and you're not going to know the translations, etc. As a practical matter, worry about the U.S. Pick the country that is going to be your biggest market, and focus on that one and try your best there, and then hopefully, will you have to rebrand? Maybe. We opened up an office in Beijing. Blank Rome has been using that mark for 50 years, but going into Beijing, we had to tweak it a little bit, I think. I don't know how it translated. The translation was funny, so I think we had to translate, Oh. Yeah, so there's really no easy way to do it that I'm aware of. We'll often write to, we have relationships in every country with other attorneys, so other patent attorneys, other trademark attorneys. It's a whole network of thing that if I want to file in Brazil, I will reach out to an attorney in Brazil that we've worked with before, and I'll say, this is the situation, do you think we're going to have a problem? And they'll do a search there, or they'll do whatever we need them to do. So it's not. There's no simple solution there.
Could a business founder do his or her own search in the United States? You have a bullet point up there about obtain a search and opinion letter. If it's just in the United States, would they need to use an attorney to do that?
So the test is whether, I kind of mentioned it before, but whether what you're intending to do is confusingly similar, and it's based upon a comparison of the spelling, of the pronunciation, of the goods or services, a few things. Now, most people are going to be able to judge for themselves. You're not going to want to necessarily pick a mark. If you know somebody has a similar mark, you're not going to want that anyway, because you don't want there to be confusion. You don't want to be building goodwill in your company only to have somebody think it belongs to this other company.
Unless it's a totally unrelated product or service.
Right, exactly. Yeah. So, when Prince denounced his name, somebody went to the trademark office and registered the word Prince. So, although it wasn't, I think they were rejected, but did I answer that question?
Yeah.
Copyrights, I think someone had a question about copyrights, so I'll just first identify what the distinction is. So patents actually don't protect an idea, they protect the implementation of the idea. So it's the product, it has to be something tangible, it can't be an abstract idea. So patents protect the implementation, trademarks protect your logo, your source identifier, how are you going to operate in commerce to represent, for people to associate that product with you. And copyright represents an expression that's placed in a tangible medium. And copyrights vest automatically. So if I put something on my website, if I do something on, take a picture or do a video, or if I, just do a painting, if I'm an artist and I paint something, as soon as you fix it in a tangible medium, it's protected by copyright. There is an advantage to registering the copyright with the Copyright Office, and it's cheap to do that. I think the fees are currently $30 or $40. And if you call them, they have very good help desks there, and they'll tell you exactly what form to use and how to do it. It's not that difficult to go through. Some people will copyright their source code. Some people are pretty sensitive about it. The way you do the source code, my understanding is you do the first 10 pages, the last 10 pages, and then you can snowflake it, meaning, it's a very legal word, meaning that you put something over it that looks like a bunch of snowflakes, and you photocopy that so you don't see all the code, you just see snippets of it, and it's enough to show that that it's your source code, so you can copyright it that way. Did you have a question?
That just hit on it. I mean, if I wanted to copyright the software that we're developing for our product.
So you can. So the thing about copyrights is it only protects you when somebody actually copies what you're doing.
Mm-hmm.
If they come up with a song, they say put enough monkeys in a room with a typewriter, they'll come up with.
So if we see the same exact functionality of another device and we say, hey, we think you're using the same code as us, I mean, how does that process? I mean.
And so the question is, if somebody has something software that looks similar, I mean, if you had a patent, if it's similar, you could go after them. You don't need to know anything else. They can't, even if it's unintentional that they didn't know about your patent, you could still sue them. But for copyright, you have to either physically copy it, look at the paper and write it, or cut and paste. And a lot of people, if you're selling something that is copyrightable, they'll put in little, I forget what they call them, but little, fake information where if you copy it, they'll see the fake information. So if it's a listing or definitions or something, they came up with the term Chinese knockoff. And I've had that situation before where somebody copied something to the T and there was a little notch in it, and I asked the client, what's that notch for? He said, well, nothing really, it's just a manufacturing thing. And the Chinese knockoff had it in there to the T. So that false information, I don't want anyone to copy someone else's stuff, but yes?
Let's say when you make your presentation for the third round business conference, let's say you use some of the images from Google. Is it infringing someone's copyright?
So if the question was, if you're using images from Google, is it infringing someone's copyright? There are a lot of sources online where you can, they say it's free to use or it's $1 to use it, and those are easy to come by. Yeah, if you're taking something off of somebody's website, it could potentially be copyrighted. What are the repercussions for it? Certainly you don't want to put it into a product that you're going to be introducing, and it may be that you could just email the site or whatever and say, are you okay with me using this? Or if you look at the site, there'll often be a legal page, and you can read through there, and it might say, we authorize, but most likely you're going to say, we don't authorize anything, don't touch our stuff. Trade secret protection, I'll just leave that in there. Again, if people are interested in getting a copy of this, just let me know. I'm happy to share it with you. I put in a few links to GWBIZ, the organization, Patent Office website. You can search your own patents there, and trademarks. Some people prefer Google patents. I'm older than that, so I don't. But Google patents are good for people. And I put up the copyright page. And that's it. Did anyone have any final questions? All right.
Thank you very much.